Hello, brothers, sisters, and friends, and welcome to You Are the Current Resident podcast. This is the official podcast of the National Association of Letter Carriers, the union that represents 280,000 active and retired city letter carriers employed by the United States Postal Service. I'm Ed Morgan, and with me, as always, is our national president, Brian Renfroe. Hey, Brian, how are you today?
Hey, Eddie, doing great. Happy to be back on the podcast. I know we've got a topic today a lot of people have been anxiously waiting to hear about, and I've been anxiously, I don't know about waiting, but ready to talk about. So,
Terrific. So, what are we here to talk about today?
yeah, so we just this week reached a tentative agreement with the Postal Service on a new collective bargaining agreement that would cover our about 200,000 active city letter carriers that we are privileged to represent. So, we're here on this episode to talk all about it, every single detail.
Oh, terrific. All right. Well, can you start by talking us through the process of getting this tentative agreement?
Sure, because I think that's a really important part is, how we got to this point. Of course, we'll get to all the details here in just a minute, but we have been negotiating with the Postal Service for some time now, going all the way back to last spring, almost 20 months in total. And if you look historically in our unions, let's call it the modern era of collective bargaining, which would go back to 1970. In 1970, letter carriers had very limited collective bargaining rights. At that point in time, we could only really bargain for working conditions and very limited benefits, and all of our pay and most of our compensation, even in terms of benefits, were subject to Congress approving an increase for us. So you can imagine what that would be like today. And a lot of brave letter carriers, and then followed by other postal employees in 1970, starting in New York City, walked out on strike. And that strike, a lot of our listeners would know, was led by a then rank and file letter carrier named Vince Sombrado that went on to become the greatest president in the history of our union. But one of the results of that strike was legislation, the 1970 Postal Reorganization Act, that gave postal employees, including letter carriers represented by the NALC, full collective bargaining rights over everything that impacts our wages, hours, or working conditions. So we consider this last 54 years or so to be the modern era of our collective bargaining. And during that period of time, if you just look at each round of bargaining, all the way back to the early 1970s, one thing that has been common is that in our negotiated agreements, and even in the ones that we've achieved through interest arbitration, which we'll get into a little bit, have always taken a long time. They've always taken months, and in most cases, even over a year, as it has taken this time. And, it's real easy to, when people ask the question, it's a perfectly legitimate question, is why does it take so long? It's very easy in some ways to say, well, it's always taken this long. But I think it's important that we dive in a little deeper than that and understand the reasons why this process historically and this time over the course of 2023 and 2024 has taken as long as it has. And it really is, in my view, a credit to my predecessors as president of the NALC. And, I'm so fortunate we have two of them that are still with us and alive and doing very well. And two additional presidents that I had before they passed away, had the opportunity to get to know a little bit and talk with. But it's a credit to all of them is that our union has this long and proud history of never settling for less than the best that we could achieve in any particular round of bargaining, given the circumstances at that time. We have at times in the past utilized the process that we have to resolve disputes in collective bargaining, interest arbitration. At other times, we have entered into interest arbitration, and while we were in that process, we've reached an agreement. That's what happened late in 2020. We reached a tentative agreement for our 2019 national agreement, the one that is currently in effect. But we have always done whatever was necessary to get the best deal that we could and never settle for less. And I think that's a huge piece of it. The second piece is just understanding kind of the magnitude of this agreement. We often celebrate with our brothers and sisters in solidarity and the labor movement with other unions that achieve victories in collective bargaining. And almost none of those other unions represent a bargaining unit as large as ours. In fact, the number of city carriers that fall under this collective bargaining agreement, it is the second largest single bargaining unit under a single collective bargaining agreement in the United States, public or private. Within, some people may have seen a tweet from the AFL-CIO, the federation that we're a member of, along with a lot of other unions, that there's 12.5 million or so members of the AFL-CIO. We are the single largest bargaining unit within the AFL-CIO. So from the union's perspective, the impact of what a collective bargaining agreement looks like and its terms, it impacts hundreds of thousands of people. It impacts hundreds of thousands of people immediately once it's ratified. It impacts those folks that are hired in the future and even long after that into their retirement even. So, it is something that has a significant impact on a whole lot of people from our perspective. Then you also have to look at it from the Postal Service's side of the table. The Postal Service, when they bargain with us, with the NALC, every single year, their largest expense is paying wages and benefits for city carriers, because we are what provides that service. There's more of us than any other classification of postal employees. The Postal Service is a service that doesn't create a product like some business, so the vast majority of their costs are related to labor, and this is the biggest piece of that cost. So when they negotiate an agreement with us, a 3, 4, 5 year agreement, which have historically been most of the time the duration of the agreements we've had, they are making decisions through collective bargaining with us that have price tags attached to them that are well over $100 billion over a few years. So it really is a grave responsibility for both sides. And that is reflected in the way it has historically been approached. Certainly, I won't speak for the Postal Service, but for our union, in that both sides have always explored every possibility to, come up with the best agreement that we possibly could. And that is exactly what we've done this time. As we go through some of the details, I'll point out certain topics that maybe some came easier than others. Some took a little bit longer, but we are very happy with the agreement as it's turned out, the economic package, as well as what we call the work rule stuff, which is essentially everything else. There's a whole lot of things there. There's some that'll be very, very significant. The second question in terms of the process that is very often answered is that the way this plays out is we open bargaining 90 days before the contract expires. If we do not have an agreement when the contract expires, we then have a period of 60 days that's mandated by law of mediation. And after that, then we can schedule interest arbitration should we have unresolved disputes. The process of interest arbitration, for those that are not as familiar, is it's essentially a court-like hearing process where you have a panel of 3 arbitrators. There is a neutral arbitrator that both sides have to agree on who that individual would be. Early this year, we chose arbitrator Dennis Nolan to serve in that role should we have needed him. The other 2 members of the panel is an arbitrator to represent the union and an arbitrator to represent the Postal Service. And their roles are to ensure that neutral arbitrator has a very clear understanding of the positions of both sides on whatever the issue may be. And ultimately, what happens is you put on a case, there are hearings, there are witness testimony presented. For us, that would have been expert witnesses on different topics. Of course, I would have testified, and maybe most importantly, we have letter carriers that testify about different topics. And ultimately, that neutral chair of that panel makes the decision on what will be in our collective bargaining agreement. And that is the process that we have, as opposed to maybe some other unions that we see in the private sector that do not have a resolution process like that. And their only recourse from the union side of things is to strike. And from the employer side of things, they can lock out the employees. So that is something that we do not deal with as federal employees. We cannot strike. So interest arbitration is the process we have for resolving disputes. So as you move through this negotiation, when there are issues that you at certain points are unable to resolve, or goals that we may have, you get into a spot where you have to determine, is the best way for me to achieve this goal, and of course, thinking within the context of the entire package of things that you're attempting to negotiate, is the best way for me to achieve this through continuing to negotiate to try to find an agreement, or is it to go ahead and move to interest arbitration? And in interest arbitration, we feel very strong about the case that we put together this year and still sit here today. We are ready to go in interest arbitration. But there's also factors that you have to consider. You have to understand what that neutral arbitrator would consider. And we at NALC are very fortunate that we have officers and we have staff that are extremely experienced in the interest arbitration process. I've been through it twice myself. One of those times we got an award back in early 2013. The other time is we basically finished our hearings in 2020 and were able to reach an agreement that our members overwhelmingly ratified prior to concluding that process back in 2020. But we have people between our attorneys and a lot of our staff that have extensive experience in interest arbitration. I'm talking going all the way back to the early to mid 1980s. So when you consider the factors that are out there, we feel like we are able to, with a fairly high degree of certainty, at least narrow down what we could expect the outcome to be. And from our side of things, of course, we're very familiar with the case that we could put on, but we also have to consider the other factors that neutral chair, that panel would consider. And if you are on the Postal Services side of the table, or frankly, almost any employer, when it comes to economic issues, which are the most important, I mean, there's a lot of things that are important to us to do with our jobs as it relates to hours and working conditions and other things. But ultimately, the reason we all go to work is to earn a living. The number one defense, so to speak, against any union proposal that an employer is going to have is going to be financial. And while we have made an effort for well over a decade now to address a number of issues that have contributed to the Postal Service's financial problems, most of them policy related, things that were created by Congress or the administration. And look, we've had some success. We passed a postal reform bill that was signed into law in 2022 that's beginning to have some impact. It will certainly have a positive impact long term. But there's also a fact of, in the last fiscal year, which ended September 30th, 2023, the Postal Service lost $6.5 billion. This past fiscal year, which just ended a few weeks ago, almost 3 weeks ago, September the 30th, 2024, while they have not announced their financial results yet, that'll happen probably around the middle of November. We fully expect they're going to lose more than the $6.5 billion that they lost the year before, which creates a challenge. So when we look at each of our economic goals and where we are in negotiations and what we are attempting to do to achieve them, you always consider, if we took this issue forward to interest arbitration, both sides present their evidence. We, of course, know exactly what we would do. We feel like we have a very, very strong sense of what the Postal Service would do. And you have to just try to make that decision. And in this particular round of bargaining, it's my decision, and I chose to continue down the negotiation path because I thought that was our best opportunity to achieve the economic goals that we need to achieve. And that is exactly what I believe we have done here with this tentative agreement. On top of that, as you'll hear in a little while, we got a lot of things done related to work rules and Article 8 stuff. I mean, things that are going to impact a whole lot of our members on a daily basis that I think are really, really positives. And there's never a guarantee that you're able to achieve that stuff through negotiation. And kind of the last piece I'll mention about just the process. When we negotiate a tentative agreement like we have here, our members, our active members that are eligible per Article 16 of our Constitution, get the opportunity to review that tentative agreement and cast a vote. And every one of them gets to vote, and it is up to the membership to ratify that agreement or not ratify that agreement. When you go to interest arbitration and that arbitrator issues an award, that is it. There is no ratification. There is no choice by the members. So if we're able to achieve our goals through negotiation and give our members that opportunity to consider it and cast a ratification vote, that is always going to to be our preference. I think it's really important for me to thank all the NALC officers and the staff that have done a lot of work on this stuff over the years, literally now. It is something that is tedious in some ways. There are moments of wanting to bang your head against the wall because you may have an issue, and no matter how hard you try, you feel like you don't get anywhere. And sometimes you have to go back to the drawing board and all points in between. But we are really blessed to have a wonderful, wonderful group of people at NALC headquarters. Our national business agents are very helpful to me, weighing in on certain topics that they deal with on a daily basis. And then also, a lot of our branch presidents around the country, I talk to about different issues from time to time to get their thoughts. And, as I have the opportunity to travel around to regional rap sessions and other events, and other officers have the opportunity to do the same thing, the feedback and that we get from our members at those type of events is invaluable. So it really is a very, very large kind of team effort. And our people have done a magnificent job this time. So, we're happy that our perseverance has paid off here and that we were able to accomplish the things we needed to accomplish. And I'm excited for us to get into it and talk about some of the details.
Great. Just so letter carriers aren't out there with a pen and pencil, trying to write everything down that we say here, go to the website. The summary of the tentative agreement will be up there for you. Make sure you share this podcast with your brothers and sisters on the workroom floor. Make sure you send them to the website. Make sure that you're signed up and you're following our social media feed. Make sure that we're part of your news feed. And if you haven't been in a while, make sure you go to your next few union meetings, because a lot of this is going to be discussed and talked over. Make sure you're doing that so that you're an informed union member. All right, so let's get into the nitty gritty here, Brian. How long is this contract going to be for?
Yeah, and Eddie, before we do that, let me just tack on one thing to what you just said. I strongly encourage everybody listening, as Eddie said, if you haven't already, go to our website, nalc.org. It'll be right there on the front page. There's a document that really explains every single change, every new thing, every single piece of this tentative agreement. It's got projected pay charts and all sorts of stuff there. So absolutely do that. And also go to your branch meetings, especially if you have the opportunity to during the month of November. We, during the last week of October, are going to hold 4 different informational rap sessions around the country for branch leaders to attend. And I'll be at each one of those to, talk about the agreement and answer any questions that they have. So I'm sure if you're able to attend your branch meeting, that'll be an excellent opportunity, as Eddie said, to get some information. Back to the length of the agreements. The agreement is effective May 20th of last year, retroactively, and we'll talk about how that impacts back pay in just a minute. And it will run through November 7th, 2026. So it is a 42-month collective bargaining agreement.
Okay. Let's get into wages. Wage increases, the big thing, right?
Yeah, that's the most important thing. So we're going to break this down into several different pieces. And the historical structure that we have had is we have our general wage increases, which we have in every year of this agreement. We have our cost of living adjustments, which is really a protection for us against inflation that look, almost nobody has anymore. And then we've got some things in here with the structure of the pay table and increases, moving people from place to place and an increase that I'll get into. But let's start with the general wage increases. There are 3. The first one is effective November 18th of last year. So November 18th of 2023. 1.3%. The second will be effective November 23rd of this year at 1.3%. Should this agreement be ratified, both of those would be paid retroactively. I'll talk a little bit more about back pay here in just a minute. And then the third would be a 1.3% increase on November 22nd of 2025. I think it's worth pointing out, how does that compare to previous agreements? And those 3 general increases are, if you average it, which obviously is 1.3%, is on average the highest general increases we have had since the 2006 agreement, which was bargained prior to the recession in 2009, which had a dramatic impact on the Postal Service. So 1.3% each year with the general wage increases. The next piece, which is in addition to those general wage increases, is our cost of living adjustments, or COLAs. And our COLA is something that when we go into bargaining is potentially the most important thing for us to maintain. When you look historically back to 1970, in this modern era of collective bargaining, well over half of the pay raises that letter carriers have gotten in terms of dollar amounts, percentages, is due to COLA. And when we see inflation, and we have seen over the last couple of years, really, I guess 3 years now, as a result of COVID and whatever else, significant inflation. In this agreement, we were able to maintain our COLA formula, which really translates directly from inflation measured by something called the Consumer Price Index to pay increases. And we know what the first three will be. But before I tell you the numbers on those, let me just tell you the structure of this. So the first COLA is based on the July 2023 Consumer Price Index. The last COLA we got before that was based on the January 2023 index, which went into effect in early March of 2023. So we have not yet had a COLA that takes into account inflation in January, February, March, April, May, June, even though the last contract expired May 20th. So the COLA based on the July 2023 CPI index takes into account inflation in January, February, March, April, and June of last year, even though 5 of those months, almost 5 of those months, were during the previous collective bargaining agreement. So anyhow, that COLA at top step is $978 annually. The schedule for the rest of the COLAs, the next one is based on the January 2024 CPI. That one effective March the 9th this past year, $353 annually. The third one, which is based on the July 2024 CPI, is $978. So those are the three that we know right now, the 3 increases we know. That's $2,300 a year just for those 3 COLAs that we already know. Those will be paid retroactively. And again, I'll talk about back pay and what's included in that here in just a minute. There are, however, 4 more COLAs should this agreement be ratified. There will be one based on the January 2025 CPI, which would be effective in March of next year. That's the 4th one. The 5th one is based on July 2025 and would be effective September of 2025. The 6th is based on the January 2026 CPI and would be effective in March of 2026. And the 7th COLA would be effective in September 2026 based on the July 2026 CPI. The value of those other 4 COLAs are dependent on the index and what happens between now and 2026. So you will notice if you have looked at, or if you look at this summary of the tentative agreement, if you go all the way to the end, you're going to see projected pay charts. And those pay charts include projections for the COLAs. And we use the same basis that we have used for a number of years for what we project those COLAs to be. The Congressional Budget Office has a inflation forecast, which allows us to estimate them. And the estimates we have for the remaining 4 in order are $620, $604, $624, and $561 respectively going forward. So I mean, it's important to understand these are projections, but historically they have been pretty close in terms of the total number. So when you look at those projected numbers on that pay table, the dollar amount, it may not turn out to be exactly the same as what's on there, but when we look historically, when we projected, they've always been pretty close. So it's really important that we maintain that COLA. There's no change to the formula. There's no change to the way it's applied. And the 3 that I mentioned, which total over $2,300 a year will be included in the back pay that I'll talk about here in just a minute. The next piece of the wages is a modification of our pay tables. So effective, should this agreement be ratified, as soon as practicable is a terminology, but no later than 180 days after the agreement is ratified, there are three major changes that will take place. Change number one is that or actually four changes, but three that directly impact people's pay. Change number one is that in table 2, steps AA, A, and B will be eliminated. So on that effective date, which again will be within 180 days of ratification, any carrier that's in step AA, A, or B will be moved up to step C and will begin a new 46-week waiting period before advancing to step D. So after we implement this, the elimination of those three steps reduces the time it takes to get to top step by at least 92 weeks. In the event those that are PTFs that are at step AA, this happens now and then in very small offices. If they were to stay at PTF their entire career, it would actually reduce it by 138 weeks. But for everyone, it's going to be reduced by 92 weeks. This will be a significant pay increase for those, of course, going forward. After that point, when CCAs are converted to career status, they will start at what is currently step C. And one thing that's important to remember is this all takes place after we've applied the two previous general increases, after we've applied the COLAs that, yes, there's retro, there's back pay for those, but it also is going to significantly increase the pay rate. So we project at that point the starting pay for career carriers would go up once those steps are eliminated and everyone starts at step C, somewhere in the neighborhood of $4 to $5 an hour more than it is as we sit here right now. The next piece is also effective within 180 days of ratification. Our top step, step P, in table 1 and 2, will be increased by $1,000, the annual rate. Step P was created in the 2019 agreement, and it was created to be $444 more than what our previous top step was at step O. This increase of $1,000 is more than double what the gap that was established in 2019. And this is in addition to the general increases in the COLAs, and you'll see that reflected in the projected pay charts. This is a significant piece because, number one, top pay was very important to us to increase it. Number two, this impacts every single letter carrier. Whether you are at step A or you are at step O, you are going to get to step P. And when you get there, it will be a higher rate of pay than it currently is. And, that has an impact beyond just what people get paid when they're there. Almost everyone that retires, the annuity piece of their FERS is based on, their high 3-year salary average. For almost everyone, that's going to be 3 years at step P. So it has a long-term lasting impact that also increases people's retirement. The third piece, as far as the wage tables, is all the carriers that are in step P in table 1 are going to administratively be moved into step P in table 2. The pay rate at table 1 step P, table 2 step P is exactly the same. The table 1 carriers that are in steps O and below, when they reach step P in table 1, they're going to be moved to step P in table 2. This is purely administrative. It does not affect anybody's wages in any way. And you may ask, well, why would we do this? And the short answer is one of our goals here was to get to the point of having a single pay table. By eliminating those 3 steps and adding the dollar amount to top step, we have significantly modified what is now table 2. By moving these carriers from table 1 into table 2, when they reach top step and it has no impact on them, it is moving in that direction. We cannot just eliminate table 1 right now. There's a lot of reasons. When letter carriers are injured on the job, their pay in terms of their step increases is frozen. They can't continue to advance. So we've got, some of our members that are throughout table one at different steps. And because of their status, unfortunately being injured on the job, that they're staying at this time in that step. So this is just a move in that direction. Okay, the last piece that would go into effect also after ratification involves CCAs. So with CCAs, there's a couple of different pieces here. Let me start with the general wage increases. CCAs get the same general wage increases as other city carriers. They will receive 1.3% in November of 2023, November of 2024, and November of 2025. In addition to that, because CCAs are not included in cost of living adjustment, they get an additional 1%. So effectively, CCAs get 2.3% every year of the contract. In addition to that, within 180 days of ratification, on top of those 2.3% raises, CCA pay will be increased by an additional 50 cents per hour. And if you look at the projected pay charts, you'll be able to really see what that, based on our projections, would look like over the course of the agreement. I mentioned this earlier, but I think it's worth mentioning again. A piece of this is CCA pays going up, yes. But when those CCAs convert, and every CCA converts no later than 24 months after they're hired, the increase currently from the CCA rate to the Step A rate is about $3 an hour, give or take. That is basically going to double once all this stuff is implemented. So, based on the CCA pay increases, but also more so on the modifications to Table 2 to eliminate those early steps. So when they convert, they're going to convert once this is implemented and start at Step C, which will be a significantly larger gap, a bigger jump in pay than what they currently experience when they convert. So let's talk about back pay a little bit. Back pay, number one, the thing I want to be clear about is all those increases I just talked about, the general increases of 2023, the one that's going to happen in 2024, coming up here in a few weeks in November, the three COLAs, probably at least one COLA next year based on the timing of our ratification, all of that's included in back pay. It is what you may call full back pay. There is no reduction. There is no lump sums. Every single hour, minute that anybody worked after any of those increases went into effect retroactively, you will be paid full back pay for that. The COLAs in some contracts in years past, just as a result of negotiations, there's been lump sums paid rather than rolling it into our base pay. That is not the case. It is all rolled into our base pay. It is 100% back pay. For a lot of our members out there, that is going to be a significant amount of money. Just the three COLAs we know of are $2,300 a year base salary at Step P. That doesn't include overtime. That doesn't even include the general wage increases. So the back pay for most people would be significant. The natural question that comes as soon as we reach a tentative agreement is, when would back pay be paid? And what I will tell you is, of course, the Postal Service doesn't do anything with back pay until the contract is ratified. Once it is ratified, they will start calculating it. And look, it's just a reality. To do more than 200,000 back pay calculations takes some time. So typically it takes a few months to get it all processed and then paid. And should this agreement be ratified, as soon as we know the timing of that back pay, we will communicate it to our members. One thing that you'll see a note in the summary that I want to point out that comes up sometimes is there are often letter carriers that worked at some point during the back pay period and then retired. And the question is, do they get back pay? And the answer is yes. If you worked as a letter carrier during the back pay period at any point in time, even if you've retired, you will get back pay. The way they've done this in the past is they would cut a paper check, mail that check to the office where you were when you retired, and you go pick it up. Additionally, some of those people, based on that retroactive pay, it would impact their high three, therefore their annuities through the Office of Personnel Management, their retirement, the amount would be affected. The Office of Personnel Management will adjust that. They will do it retroactively. it's an impact and it increases it usually a little bit, usually not more than maybe a few dollars a month. That we have even less control over the timing. And anyone that's listening to this that has retired recently is probably aware that sometimes the Office of Personnel Management is deliberate, let's say, about some of the things they have to process. So, in a nutshell, that's everything to do with the pay. We, as I said, are pleased with the way this worked out. Really, the pay charts tell the story. If you look at this summary, go to the end, look at those projected pay charts. You can see there at what points, depending on what step you're at, you can see what you would be making, into the future with the COLA projections that we have. It really, shows everything about to everyone, no matter what your circumstance is. So we encourage you to take a look at that.
I was just about to say that. Try to get in where you fit in. Check out the charts, see where you are, see where
Yep.
you're going to be.
Yep.
All right. Next, let's get into uniforms.
Yeah. So uniforms was a hot topic during this entire round of bargaining, and it's a topic that this is not always the case with a topic in bargaining, but it's actually something that both us and the Postal Service at this point, really have an interest in addressing. For us, it is simply a matter of the cost of uniforms has just gone bananas. Um, and our members are really not able to get, in most cases, the things that we need. So there is uniform allowance increases next year. It goes up to $536. If you're a newly eligible carrier, you get an extra 125, and then in 2026, I don't know if it said this, May 21st of 25 goes to 536. May 21st of 26, it goes to 549. But the bigger piece here is that the parties are committed, and we have an MOU that reflects this that we put in the last agreement. We have to change this program to control costs, because what traditionally happens is no matter how much we raise the uniform allowance, the price of uniforms just goes up with it. And that's been our experience. So from our perspective, our members, because of the prices, are not able to get the uniform items that they need, that the Postal Service requires us to wear. And then from the Postal Service's perspective, their interest is that as those prices go up, so do their costs. So we have done a good amount of work on what a new uniform program would look like, that allowed for better cost control and allowed us to get the uniform items that we need. There's also a new piece here to do with uniforms that we have not had before. And that is, in the event someone doesn't spend their uniform allowance, the ability to carry it over from one year to another. So under current rules, it's been this way for a long time, you get your uniform allowance. If you don't use it by your anniversary date, you lose it. But now we are going to have the ability to carry it over. The language as it's written is frankly a little bit difficult to understand, but in a nutshell, what it means is if you do not use your allowance after the first year, you've been given an allowance and then you don't use it, your anniversary date comes, you can carry it over. You just cannot at any point in time exceed 2 full years worth of uniform allowance. So in May, the allowance is going to increase to $536. That just means the most you could carry over would be $536, because on your anniversary date, you would be given that amount, the amount for the next year. So you can't have more than a total of 2 years worth of allowances. This is going to take them some time to implement. We believe it will be implemented more than likely sometime late next year. That there's people's anniversary dates are staggered all throughout the year. But in talking to the Postal Service, that's where they think they can program it. So, that's a good thing for those people that have either made the mistake or intentionally not use their full uniform allowance. At least now they don't lose it. It will carry over to the next year.
All right. How about the employee complement?
Yeah, so this is a big thing over, has been a big thing over the last several years. And when you read the summary, you'll see multiple MOUs and just references to Article 7. And a lot of this is just kind of cleaning things up. But I'll go through it without getting too deep and nerdy into some of the topics. The first is in Article 7. So in Article 7, Section 1C, this is since we have had city carrier assistance going back to 2013. This is the section of Article 7 that puts caps on the number of CCAs the Postal Service can employ by district. And since 2013, that language is said in Article 7, Section 1C1, that they could not have more than 15% of the full-time, a number equal to 15% of the full-time carriers in the district. And then Article 7, Section 1C2 talks about that they get an additional 8,000, but it is capped at 8% of full-time within each district. So that language kind of dates back to in 2013, the DOS award. We had almost no PTFs then. It was, in fact, there was a memo back then that said that as a result of the award, that there was an expectation to phase out PTFs. Well, that didn't happen. They brought PTFs back and got more of them than we've had in, I don't know, 15 plus years at this point. But as we have sort of brought that category back over the years through various agreements, we have, in some cases, counted them as full-time for the purposes of determining that cap in Article 7. And then in the 2019 agreement, when we agreed to the MOU that results in the CCAs being automatically converted to PTF status after 24 months, there's a line in that MOU that said that those PTFs, once they're created, would be counted as full-time for the purposes of those caps. The combination of that and these kind of side agreements I'm talking about, where we did conversions here and there and everywhere, I think we had like 9 or 10 different categories of PTFs that were converted in a way that counted under the caps, and then we had a handful that did not count. Basically, it got very complicated to track. And at this point, this change is to change the language in Article 7 from basing that 15 and 8% on the number of full-time carriers to career carriers. This is not going to change their cap numbers. The Postal Service right now is under their cap in every single district. Sometimes you got to give them credit. This is a battle we had to fight in a lot of districts for a number of years, but they've done a really good job here the last year and a half to really 2 years, I'd say, back to sometime in 22, of staying under that number. It's only going to change that number in some districts by a few. So it's really more about just simplifying that language. I mentioned in the MOU that results in the automatic conversion that they were counted for full-time. Obviously, because we made this change in Article 7, that line will be deleted. So, when you look at the actual tentative agreement, which we'll have, when we do the ratification vote, if you see that line is deleted, that's why. The next piece that is pretty significant is the MOU full-time regular opportunities in our craft. This is the agreement that it's been in our national agreement going back a few years now. The first kind of variation of this one was in November of 2013, and we got CCAs as a result of the DOS award, and then we had to negotiate a kind of a mechanism for them to convert to career status, and it's evolved over the years, and it's a really good process now. I mean, it's a process now where when we have a vacant route, there's a sort of a pecking order of how it's filled, and it maintains a healthy, ratio of giving people the opportunity to transfer versus converting PTFs and giving them the opportunity to transfer, and also giving CCAs, of course, the opportunity to convert to career status. And there's a couple of changes we made here. One of them is related to the fact that we do have a lot of PTFs now. So in this memo, the first variation of it that I talked about was done in 2013. We had very few PTFs. Now we got a lot of PTFs, which is a good thing. We got a lot more career people. But when they transfer from place to place, and there are other PTFs there, we had to address some language to do with where they go in seniority when they when they arrive. This is just kind of incorporating an agreement that we did after ratification of the 2021 agreement to clarify that PTF piece. The second piece, which is significant in this MOU, we have used a process in a number of places over the years. It comes to mind, we used it out in the Bay Area in California. I think we've used it in Colorado, where we have a review process to help with staffing to identify what we call carriers that are on the rolls but not available, or ORNA, ORNA. And whenever we have a carrier that's on the rolls not available, what happens is on paper, there's a carrier on this route, but the reality, which is what matters, is day in, day out, there's no carrier on that route. So you may have a PTF or a CCA who's there. It's great they can get a hold down on that route, but that can impact overall staff. The piece that's been inserted here is a review that will now happen nationally, that when we have full-time city carriers that are on leave without pay for 13 consecutive pay periods, which is 6 months, and it just says leave without pay. It could be for sick leave. Some of those people may be, injured employees. They might be, full-time union officials. There's a lot of different 204Bs. There's a lot of different possibilities. When they've been gone for 6 months, we create an additional full-time assignment and then fill it through the procedure and the process in this MOU. That is a really, really good thing that will help in places that for one reason or the other happen to be impacted. So you create an additional full-time job. That's a good thing. That is going to result in a conversion to either full-time from a PTF or a CCA converting to career to fill that job. And plus, you've got a full-time employee to fill that vacancy that's there. The next one has to do with what we call holiday carrier assistants, and these are employees that the Postal Service can hire during the holiday season. This is something that's been in place. It's been in place really for a long time, depending on what classification of employees we had. But since 2013, we've had this MOU that during the December period, the Postal Service could hire what they call holiday carrier assistants to assist with holiday work during peak season. And what we've done here is modified this MOU in two ways. Number one, we have extended that 4-week period by 2 weeks. And the reason we've done that is peak season now, letter carriers listening, this, basically starts at Thanksgiving. Black Friday and Cyber Monday has turned into way less of a, sit outside the store and whatever, wait till it opens at midnight or whatever. The people used to go crazy like shopping on Black Friday. It's really transitioned much more into online shopping, which hits us hard that week after Thanksgiving. So it just, for 2 more weeks, it allows them to employ these holiday carrier assistants. The language in the MOU remains that if a holiday carrier assistant is there and a CCA is there, the Post Service has to give the work to the CCA first. So it's not like they can bring these holiday carrier assistants in and then give them other people's work. It's just additional help. On top of that 2-week window, there is an additional 2-week window before where they can put them on the rolls just for the purpose of training them, but they cannot perform any work in our craft. So, what used to happen, and we've done MOUs on a yearly basis to allow them to do this. What used to happen is you had them for 4 weeks, they hired them, and they had 2 choices. They could either train them, and it cuts into that 4 weeks, or unfortunately, in more cases, they probably didn't even train them. They just hired them and stuck them out there on the street. So starting in sometime basically in early November, they can put them on the rolls. They can train them. They cannot perform work, only training. And then after that, starting around a couple weeks before, around the middle to the second part of November, we've extended that period. Okay, the next one is a new MOU that will establish a test for what we are calling multi-installation carrier technician assignments. So around the country, we've got a number of little geographic areas where, and this applies to offices level 21 and below. So we're talking kind of smallish, medium-sized offices to smaller, where we have maybe less than 5 routes, or we've got, a circumstance where you have maybe 12 routes or 13 routes. So you've got 2 carrier technicians, and then, you don't have enough assignments to create another full-time carrier technician job. And in this test, we would be able to group up to 3 installations together and create a care technician assignment that could have daily assignments at each of those different installations. So it's more full-time jobs, which is always a good thing, gives our members the opportunity to bid on. Plus, it'll be helpful in those locations to know you've got a full-time carrier that on a normal schedule, when the regular carrier is off, that's going to be who carries that assignment. That can help with staffing and a number of different things. So this is a test. We'll have to find some places to work through that. Just like any other test, sometimes you do one of these and it's be a great idea, but you learn some lessons and hopefully, this evolves into something we can implement more broadly after we test it. Next is an MOU that we put in the 2019 agreement called Complement and Staffing. This has been modified some to recognize what we have done over the last few years and then also establish we're going to continue to do that. And what we have done is established a review process that happens every single week where we look at offices / districts around the country where we think they're having staffing problems. We do a really, really deep dive jointly with the Postal Service into why they have staffing problems. Is it that they've got, I was talking about the ORNAs a few minutes ago, people that are on the rolls not available. Is it, some places they've had trouble hiring enough people, whatever the case may be. And we have agreed on, as a result of those discussions, moving several hundred installations to an all-career model where we converted all the CCAs to PTFs and we start hiring PTFs in those places off the street. That is going to continue. And that is a really positive thing. Post Services that's actually continued throughout negotiations, which is kind of unusual. Usually when we're bargaining, stuff like that doesn't keep going. But in this case, it has. So that's really what the change in that MOU is. The last one that I'll mention, Eddie, as it relates to complement, just we listed in the summary. It's not really it's not a substantive change, but it's worth mentioning. So there's an old MOU. I say old because it's been there a long time. It's called Article 7, 12, and 13, crossing craft and office size. And we this is a type of MOU that is, for the most part, used at headquarters. I mean, now and then you might see it pop up in an Article 12 grievance or something that involves accessing to or from or mandatory return under Article 12 from one craft to another. But we call this the bridge memo. And basically what this memo says is that among the bargaining units represented by us, the mail handlers, and the APW, rural carriers are not part of this. Things related to transfers and the stuff in Article 7 and 12 and 13 that have some impact that results in craft crossing. So for whatever reason you're doing work in another craft would continue as they were at that point in time. And this dates back to prior to the mid 90s. We had something called the Joint Bargaining Committee, the JBC, where we bargained jointly with the APW and the mail handlers. That split up, and this MOU has remained. Over the years, it's the MOU is still there. We kind of have an understanding with the other unions when it comes to negotiating stuff like conversion memos. They have MOUs like the full-time opportunities memo we have that we did back in 2013, and then after that, they created kind of their versions of it. We discuss it when there's an impact, and as long as it works for everybody, it's fine. But the change here is that we are replacing the term man year with work year. And I am, to be quite honest, very disappointed that that wasn't done in 2019. So, because we've done our best to try to update terminology like that. So that's the only real material change. It doesn't really impact anything in terms of the way Article 7 or 12 or 13 and those cross-craft provisions, the way they work.
Great. Our next subject is going to be health insurance premiums.
Yeah, so this one is real simple and real easy. There are no changes to health insurance premiums. So is that we will continue to pay the same percentage. The Postal Service will continue to pay their same percentage for career letter carriers. That means the Post Service will, their contributions is 72%. For CCAs, they pay 75%. And that's, when they have the non-career, the Post Service non-career plan. So I just to give a little bit of context, some of you that have been around a while will remember for a number of contracts, we had a kind of gradual shift in percentage from what the Post Service paid to what we paid. So our percentage gradually increased. I'm talking this is over whatever it was, 12 years or something. Currently, and the reason for that is the rest of the federal government, the government pays 72%, we pay 28. That's what ours is right now. And there's no modification here. We do not see, certainly not in this agreement, do we? And really in the future, we expect that will remain consistent. So, what we pay with for health insurance stays the same. And while we're on health insurance, it's open season starts November 11th. And if you don't have the NALC health benefit plan, go sign up for it November 11th. I've talked to a lot of letter carriers over the years, thousands, about their health care. And I've talked to a whole bunch of them that over the years that have swapped to the NALC health benefit plan. I've never once heard someone say they regret it. It's going to be the best coverage you can get at the best cost. It's a plan that we run, and we run it, and it exists for one reason and one reason only, and that is to provide the best health care we can for letter carriers at the best price.
There's a great article in this September and October's Postal Record, page 7, talking about open season coming up.
For sure.
Yep. All right, up next, the overtime provisions.
Yes. So there's some big stuff here, and this is so I have worked on collective bargaining at headquarters, and now this is the fourth round of collective bargaining. The last two I was executive vice president, and spent a ton of time on these types of topics, and we have attempted to negotiate all kinds of stuff over the years, and we are really excited about what the changes that are here. And I think what I'm going to do, instead of explaining this kind of in a nerdy way by Article 8, Section this, and starting with 2D and going to 4G, and then that's new, and then down to what we're doing in 8 5G. I think I'm just going to sort of explain the two major changes. And as you read the summary, you'll see it's separated by section. But just to, in a nutshell, explain the changes. Let me start with the change related to maximum work hours and pay that is new. So back when I was a kid in the 1980s, may have been the late 70s. I don't remember off the top of my head. One of our really respected national arbitrators named Richard Mittenthal, he issued an arbitration award that said maximum work hours are absolute. You can't volunteer to work over. They can't make you work over. They're absolute. The reality is that since that time, the way it's played out, as a lot of you listening know, is our folks have had to work over the maximum work hours, which is 11 and a half hours a day. I mean, unless you're on the ODL, and that's 12 hours a day and 60 in a week. So much so that we had a national level grievance a few years later about when someone does work over this maximum work hours, what's the remedy? And the remedy from another well-respected arbitrator named Carlton Snow was that you would receive an additional 50% pay. You already would be paid at the penalty rate, double time, because you were working past 10 hours. So effectively, what that meant is going forward, what's happened in a lot of places, and a lot of you listening to this are stewards and branch officers that have filed a gazillion grievances on this. Your people having to work, being forced to work past their maximum work hours. You have to file a grievance. Then you get the extra 50% pay. So here is what is going to change. There's new language in Section 2 that will make crystal clear that letter carriers that are not on the ODL and not on the work or on the work assignment list. So every single full-time letter carrier that is not on the overtime desired list cannot work past 11 and a half hours or 60 hours in a week. They also will be able to, the carrier, terminate their tour when they reach those maximum work hours, and they shall not be disciplined for doing so. The contract is going to say that. So this shifts and gives us something that we have in the places where this has been violated over and over and over. What stops it is giving the carrier the right to refuse. And that's essentially what this will be. They cannot volunteer to work over. They cannot work over those maximum hours. And when they get to those maximum hours, they clock out and they go home, and they cannot be disciplined for it. And that is a really big step forward for us. We are excited to have, them to have the opportunity to do that. The second piece, as it relates to these maximum work hours, has to do with ODLs. And this is new language that you'll see. There's a new paragraph added to Article 8, Section 5G. And that is that ODL carriers who are limited to 12 hours in a day and 60 in a week by that same section also cannot be forced to work past 12 hours or 60 hours in a week. They will also be able to clock out and go home and be protected from discipline. The contract will say they shall not be disciplined for terminating their tour. However, those that are on the ODL may volunteer if they want to work past those maximum work hours of 12 or 60 in a week. But it's up to them. If they want to do it, they can volunteer to do it. If they don't want to do it, they clock out and go home, and they cannot be disciplined for going home. The pay piece of this is that for any letter carrier that works over 12 hours in a day or over 60 hours in a week, there is a new pay rate, and that new pay rate is 2.5 times pay. So if someone volunteers to work over and they work over 12, they work over 60, they're on the ODL, they are automatically going to be paid 2.5 times pay. So now you got straight time, you got overtime, you got penalty when that kicks in. When 12 hours in a day or 60 hours in a week kicks in, there's a new, I don't know what you call it, penalty and a half, maybe 2.5 times pay. That applies to all letter carriers. It doesn't matter if they're CCAs, PTFs, full-time. It doesn't matter why they work over. It's a pay rate, no difference in penalty or overtime. So those are the changes that relates to maximum work hours. It creates opportunities for the ODLs that may wish to work more than that. But for all full-time carriers, they now will have the ability when they get to the maximum work hours to leave and go home, and they can't be disciplined for it. The next piece that is significant is the overtime lists themselves. So there is no significant change to the work assignment list at all. It basically stays the same. But there is a change to the ODL. It's basically been separated now into two different, let's call it pieces. Piece number one is going to be an overtime desired list that someone desires to work up to 12 hours a day on any assignment on their regularly scheduled day, but not their non-scheduled day. That's one list. Then there's another list you can sign where you don't want to work over 8 hours, but you are willing to work your non-scheduled day. If you sign both lists, then you are effectively on what we have known for a long time now as the ODL. So it's just additional options. And the piece of this that we had to kind of figure out, that I'm sure those of you that are shop stewards out there that are used to dealing with equitability quarterly, I'm sure this is the first thing popped into your mind is how on this earth does equitability work with that? And the answer is that you now have three possibilities. You've got the list where up to 12 hours, but on a regularly scheduled day. You've got I'll work my non-scheduled day, but I don't want to work over 8. Then you've got what we now know is the ODL. If you sign both, they just have to be equitable within the people that are on whatever list they're on. And all the other equitability rules apply. One thing I'll mention, because it's related to equitability, and this will be in the JCAM, is when an ODL volunteers to work beyond 12 in a day or 60 in a week, that time they work on a volunteer basis beyond 12 or 60 is not included in equitability. It's just excluded altogether because, one, I don't think it's fair to say, well, such and such had the opportunity and chose to go home at 12 hours. That's kind of ridiculous. And, the actual number of opportunities for people to do that should, once a lot of this is implemented, hopefully really be kind of very uncommon. So that'll be a change to equitability. But those are, and the one last piece with the ODLs, there will no longer be a 10-hour preference. There was for the longest time when you signed the ODL, you were able to indicate, whether you preferred the 10 or 12-hour list. It wasn't really, they're not separate lists. And it really, to be honest, only came into play when you got to the point of needing overtime beyond 10 hours and you had an ODL that had a 10-hour preference, one had a 12-hour preference, you give it to the one with the 12-hour preference. So that 10-hour preference will now be gone. But those are changes to Article 8 that give us more opportunities. And they also will give every single letter carrier, when they get to those maximum work hours, the ability to go home and know that I'm not going to have to work. That is the absolute latest that I'm going to have to work. So that's a big piece that we're excited about. Significant changes, that the type things we've been working on for a long time. Really, that whole piece about the volunteering to work over versus the discipline protection, I'll be honest, that was a bear for us to get done. That's one of the things that we worked on for a long time, and really was a piece, kind of the last piece of the puzzle that we just wrapped up kind of late last week. So we're excited about these Article 8 changes.
Yeah, I didn't want to interrupt you there, but a few times I was saying to myself, amen, amen, and thank you, thank you. I know a lot of letter carriers are going to really like this part of the contract. Anyway, let's move on. Let's talk about our layoff protection.
Yep. So our layoff protection, that, once letter carrier's got 6 years, you're protected from layoffs. That is maintained with no change. So that protection is still there. The same is true Eddie, I can say quickly, that's not really related, but is important, equally as important, that we frankly don't talk a lot about now, or haven't about in some time, thankfully, because the current leadership of the Postal Service is not really showing much of an interest in doing this, thank goodness, is these protections against subcontracting of our work, which those have been around a while. Remember, back in the bargain for the 2006 agreement was a huge, huge, huge fight. And in that agreement, we achieved significant protections, both in Article 32 as well as some MOUs against contracting out of our work, and that those agreements have been continued, and look, they've served us really well. And this is always a topic in bargaining. And we're very pleased that those existing protections will be continued into this agreement.
Let's continue with a few more MOUs. The City Delivery and Workplace Improvement Task Force.
Yeah, this is one that's been around for a little while now, but it's really served us well. It covers a lot of different stuff. I mean, it covers stuff from work environment and culture to efficiency and space and staffing and route adjustment, safety and contractual compliance, all kinds of stuff. And the way we've done this is we have sort of a high level group that meets, and then we divide by topic into what we call subcommittees. And we have different officers and staff at headquarters, post service folks that work on these particular topics. And some of the things that we're talking about here have resulted from this task force. For example, we're about to talk about a new employee retention program resulted from this task force. The staffing review that I talked about earlier that's resulted in the all career, the offices being moved to all career, that came from this task force. There's some safety stuff in here that's pretty significant to do with district safety committees, and some of that came from this task force. Route adjustment stuff, a lot of what we've done route adjustment wise and will do has come from this group. So it's just kind of a center point for a lot of the things that are related to the everyday job of the letter carrier for us to talk about. Having a contract, that means the Post Service has to do it. They have to participate in it with us, and they have, to their credit. So we're excited we made some modifications, not major, just some language that we cleaned up and changed based on our experience. So we've got some really, I think, exciting ideas to cover some of those topics, and we're excited to get going on that, hopefully once we're ratified.
All right. And we want to get into that new employee experience.
Yeah. So this is I think a big deal. We have, the Postal Service historically, all of us that Eddie, you and I talking, and whoever's listening to this, we all at some point kind of talk about, the old story of we walked uphill barefoot in the snow to work our first few days, all that kind of stuff.
Mhm.
Um, but look, the reality is, we think it's very important that when we hire letter carriers, that we give them the best opportunity to learn and succeed in doing this job. And the fact of the matter is, this job's hard, and you don't get experience doing this job anywhere else. So, and under that city delivery task force I talked about, we started working and developed a program a few years ago that we have been testing. And I think we've got several hundred offices around the country that participate in it now. And it's a comprehensive program that structures from the day that a CCA or PTF, whatever the case may be, is hired. It goes through what happens with the training. When they get done with the training experience, it limits their work hours for different increments as they get into their career. It incorporates reviews. The union's involved in doing that. It talks about different types of training that they have to have. I mean, it structures a schedule for them early on so they have the best opportunity to learn. There's just a lot of, I won't get into every single detail. It's laid out pretty well in the summary that we've talked about now a few times. So if you read that, but one thing I want to mention, Eddie, that's related to it, that's actually contractual language in Article 8 that I think is a really big piece of this. Is I mentioned there were work hour limits, but beyond this program, there's new language that's going to be inserted into Article 8 that basically says PTFs and CCAs have to have a day off every week. That they are limited; they can't work more than 6 days a week, except during the penalty exclusion period in December, which people would understand why that's the case. So I think that's a really, really good thing. That addresses the kind of extreme circumstances that we frankly have not had a ton of recently, but we have had periods where staffing problems in locations resulted in people working way too many days in a row. But going forward, PTS and CCAs will have to have a day off.
Okay. And do we want to talk about the joint workplace and improvement process?
Sure. So this is an existing agreement. It's called the JWIP. We have significantly changed this agreement, and we changed it based on a few different things. One, our experience with it. This was a brand new thing we came up with in a previous round of bargaining, and really, it was new. You do the best you can with it, but you don't. Sometimes it can be really hard to envision exactly what would be the most effective way to structure something or identify places. But the intent of this thing was for us to identify places where we've just got problems related to relationships at the local level and bad cultures, which almost always come from you know poor contract compliance and behavior of with managers. So this was initially intended to just be a process that creates an additional avenue for us to jointly look at some of those, in addition to the grievance process, of course, and other tools that we might have. So what we've done here is changed it to a structure that we think is going to allow it to have a little broader reach, but also I think there'll be more resources committed to it on both sides in terms of the number of people that we have that we can match up that can go in these places and sort of objectively identify what the problems are. It's a little more local, geared toward as far as the structure locally. Early on, as likely it should have been. It was very national in nature when it was very new because we wanted to start sort of slow and learn, and we indeed did learn, and we're pretty confident that we've got a place here that working through our MBA offices obviously would be the primary starting point for most of this stuff, but it's going to contractually give us another way to address a lot of some of the issues that are happening in a lot of our workroom floors around the country.
Next, we're going to talk about local implementation. Easy for me to say.
Yeah,
And do you want to maybe talk about, people this might be their first contract they've been through, or for
sure.
our more experienced carriers, they might want dates.
Yeah. So in our contract in Article 30, there are 22 items that are identified that can be negotiated at the local level. I'm sure a lot of you listening, even if you don't have any direct familiarity with your local, it's called a local memorandum of understanding. But it covers, a number of different things. It covers kind of how your vacation scheduling works for one thing. There's several topics that are very localized, and every contract we have a period where after a contract is effective, in this case negotiated deal, and should it be ratified, we have a 30-day period where the parties at the local level, the postmaster and the branch president or their designees, their committees, sit down, and there's a process for them to discuss and negotiate the items that I talked about that are in Article 30 of our agreement that can go into their local memorandum of understanding. So in every contract, we have to do a MOU that identifies what that process is and what the dates are. And with this agreement, should it be ratified, that local implementation period would begin on April 3rd of 2025, and the 30 days would run to May 2nd of 2025. Ratification wise, we anticipate that chances are, if ratified, that would take place, be finalized sometime probably in late December, early January. So the idea there is to ensure that our folks locally have, once ratified, if indeed that happens, they have ample time to complete their preparations and be ready to negotiate those items in their local agreement.
Next up is the route evaluation and adjustment process.
Yeah, there's a couple that I'll mention here. A number of existing MOUs will continue. One of them I think is worth mentioning. We put in the summary the alternate route evaluation adjustment process MOU that creates a task force of sorts, and has required us and the Postal Service to jointly explore route adjustment processes. And this MOU, it's been changed over the years. We've modified it in different ways, but it has resulted in all the joint processes that we've had. We've had 6 as a result of this MOU. We had IRAP 2008, MIRAP 2009, JRAP 2010, JRAP returns in 2011, and we had CDRAP in 2014, and then we had TIRAP back a couple years ago. So that continues, and I can tell you both parties are committed to continuing to refine and develop the best joint processes that we possibly can develop. For me, this is something that I have in the whatever it's been now, 13 years or so that I've been at NALC headquarters. It's the topic that I've spent the majority of my time on over that period of time, and been heavily negotiated most of those. And I firmly believe it's the best way to adjust routes if we have a fair agreement, and the other side is willing to play ball and follow the agreement, and which we all know we've had some problems with over the years. So, look, we're committed to doing it. The Postal Service maintains an interest in it. Normally, what happens is we have a joint process. They don't like how it turns out in the end, the results. So then they get sad for a little while. That's already happened with TIRAP. They think they added too many routes and all this stuff. They come back to the table pretty quick here. So we are going to get to work on that really quick. So that'll continue. When it would or if it'll result in another joint process, I don't know. That's just really comes down to whether or not they're willing to address some of the things that we know we need to address that we experienced during this past joint process. There's a lot of stuff that came up, but a lot of it honestly was not problematic in terms of the language in the agreements. It's more about their behavior. The second one is a new MOU that has to do with fixed office time. I think it's really important to explain what this MOU is and the reason for it. But first, there could very well be some carriers listening that maybe don't have a lot of experience with route adjustments, or maybe don't have an understanding of what fixed office time is. So let me start with what it is, and then I'm going to talk about the agreement itself. So fixed office time is a way that in a route evaluation, when we determine, what your route is in order to determine if, any type of adjustment needs to be made. Fixed office time is how we measure activities that we do in the office other than casing and pulling down mail. So casing mail, there's a standard for that. Pulling down, 18 letters or 8 flats a minute. Pulling down mail is standard for that, 70 pieces per minute. Those are two components of how we build a quote standard office time. The other piece is fixed office time. And the way that we measure fixed office time is currently by recording certain activities on what we call certain line items. So there in chapter 2 of handbook M39, there's just a whole, which covers everything to do with route adjustments. There's a whole list of, line number, this covers this activity. And here's, there's a minimum time allowance for all of those. And in every joint process, we have had to bargain what that fixed office time component would be. Now, in a normal route adjustment process where there's a manager, there with their clipboard and paper, and they're recording everything that you do, they just record like how much time it actually takes, and, that's what it is. But the fact is that the system was created during a point in time when our office work was very different. It was created back during a time when we handled a lot more mail in the office. We cased a lot more mail. The distribution of mail from the clerks was very different. Office time, just to give those of you that are newer carriers, this is going to blow your mind. Office time, probably average office time at the time the current model of measuring fixed office time was created was probably 2.5 hours, 3 hours. Who knows? Maybe even more than that. So there was a lot of stuff that you had to do. You're casing tons of mail, so you got a lot more, mail. There was no DPS even, so there was a lot more mail that you had to handle. So more mail resulted in more activities that were not part of casing or pulling down mail. And as we all know, that has significantly changed. We all are now casing less mail, which means there's less activities. And not only is there fewer activities, some of the activities themselves have changed significantly. So we have actually been talking about this with the Postal Service for some time. And the combination of, the time we're in the office being less mail, which impacts the activities. Now the Postal Service is creating these SNDCs and workroom floors. When someone moves from a smaller station, they move into one of these SNDCs, you might have to walk the other end of the warehouse or whatever to get your parcel. So there's like all sorts of just changing things here that have happened over time. And we have always believed that, with a couple of exceptions that I'll talk about in a minute, that really what it comes down to, when you want to measure fixed office time for the purposes of creating a standard, it really should just fall in one of two categories. It's either recurring, it's something you do every day, like check your vehicle or get your accountables, or it's non-recurring. It's something that happens, that's out of the ordinary. I don't normally do this. Let's say you get someone, comes in and there's a spill by your case and you have to go sit and wait for a few, something like that. Obviously you wouldn't record as recurring. Currently that'd be recorded on what we call line 22, which is, office work that's not covered, that's non-recurring. So the idea would be that we could record it as recurring or non-recurring. And we have explored this in different, negotiations for joint processes, and we really got into it in this round of bargaining. There's been a lot of testing done. There's been some testing that we have done jointly. There's other testing the Postal Service has done on their own. They have hired companies to come in and do engineered studies and all sorts of stuff about the amount of time that we spend on these different functions within the office. So to move towards that whole model of recurring versus non-recurring, we made some changes here. And what we decided is, in this MOU, you'll read there's a commitment to we are going to modernize the way we determine fixed office time. It is to be determined exactly what that looks like. That'll be part of a joint route adjustment process. But what this MOU also does is says, number one, two line, or I guess it would technically be 1, 2, 3, 4, 5, the 7 line items we're not going to use anymore in terms of specifically recorded in there. Lines 8 through 13, which mostly has to do with markup mail and COAs and stuff like that. And we're not going to use line 15, withdrawal of mail. It doesn't mean you don't get the time for it. It doesn't mean that it's not recorded. It just means we're not going to record it under those lines anymore. We'll record it under line 21, which is office work that's not specifically under another line that's recurring. And also, it makes very clear that in whatever modified method we come up with, the minimum line item values for 4 lines are not going to go below these numbers. And so there are 2 of them that have changed. The first is line 14, accountables, and that it will not go below 2 minutes. And remember, we're talking about when we set a minimum in a modified method of determining fixed office time. So you may say, where'd 2 minutes come from? 2 minutes came from a lot of different places. It came from a lot of studies. Frankly, a lot of those studies showed that accountable time was 1 minute. It's true that a lot of our accountable mail has been moved to the street. Everybody knows certifieds, often now come in the DPS. So the carrier, like, we get the time to do it. We take the time to do it. It's just done on the street. It also does not mean that you're going to get 2 minutes for accountables. It means that in whatever process we do, it will not go below 2 minutes. If you got a route where, it takes 10 minutes a day, then we will have a way to measure that. And that's what this accountable time will be. It's just that it won't go below that. The next one is line 19, vehicle inspection, 3 minutes. It will not go below 3 minutes. The current minimum is 3 minutes. So there's no change there. The next is line 20 for personal needs, 5 minutes, will not go below 5 minutes. That is the current minimum. It will not go below 5 minutes. It does not go below 5 minutes now. And then line 21, which is recurring office work that's not covered under the other line items. The current minimum in the M39 is 9 minutes. In the modified method we use here, it will not go below 10 minutes because we're taking some of the time that's under, that we're recording activities that used to be under lines 8 through 13 and line 15, and now we'll record them under line 21. So it won't be less than 10 minutes. So these 4 that are listed here in the summary, when you see the MOU, it'll have 0 minutes for 8 through 13 and 15, but make clear that they're now recorded under 21. These are minimums that they will be the absolute lowest in whatever modified method we come up with jointly. And it's important this is in a joint process. It's something that we, the union, would have to agree to. And once again, it's only used to construct a standard office time. And more than 2/3 of, in every route adjustment process we do, more than 2/3 of carriers, whatever their standard office time is irrelevant. We don't even use it. So it's really about moving to a simpler, more of a recurring versus non-recurring system, taking some kind of outdated activities under 8 through 13 and lines 8 through 13 and lines 15, and then establishing, a floor that no matter what we do, that this is kind of setting a starting point on values for each of these line items in a negotiation of a modified method of a joint route adjustment process.
Okay. Next in the summary is our other contractual provisions.
Yeah, let me just touch on a few. Let me start, Eddie, I think, with some that are related to, well, I'll touch on one in Article 2, which is in not something that's very frequently used, which is a good thing. But there, in Article 2, we just made a couple small changes. One is to make clear that there are protected classes there, anti discrimination, to make clear that pregnancy is a protected class, which it absolutely is and should be. And we have also replaced kind of an antiquated term, handicapped employees, with individuals with disabilities. There's a few things related to leave that I should talk about that are I think are pretty good. We have a new MOU called monetization of annual leave, and this gives our career employees, PTFs and full time, the opportunity to, if they're at the maximum carryover of leave from one year to the next, and they've used fewer than 75 hours of sick leave the year before, you can sell back 40 hours of annual leave. So you can basically cash it out and they'll pay you for that 40 hours of annual leave. You just got to meet those two requirements, having the maximum carryover, using less than 75 hours of sick leave. The next is an MOU called CCA advanced leave. So after a CCA completes their first 360-day appointment, so after 1 year, when they come back, they are going to be advanced 40 hours of annual leave. When this is, you do a year, you're reappointed, which you have to be, you come back, you get 40 hours of leave advanced to you, which is good because you get that, there's a terminal leave, and then once you come back, you can have that 40 hours of leave. For those CCAs that are, once this is implemented, that would already have a 300, completed 360-day term, they will be advanced a prorated amount depending on how much time is left in their second 360-day term. The next is in some ways similar. An MOU is called PTF, Advanced Annual Leave. For PTFs at the beginning of the year, they will be advanced 40 hours of leave too. So currently PTFs are annual leave per pay period, but now they'll be advanced 40 hours from the beginning. All right, we made a change to the MOU on bereavement leave. Bereavement leave gives our folks, our members, the opportunity to use leave for bereavement purposes, and it lists specific family members, that leave would be, that they'd be eligible to use that leave. Grandchildren will be added to the list of family members there. Then we have an MOU concerning bone marrow, stem cell, blood platelet, and organ donations. This MOU just kind of lists the amounts of administrative leave per the M that is granted to each of those people that take leave and the people that do that kind of stuff. That's a wonderful thing you can do for other human beings. So it's a really good thing. Article 11, there's a couple of things I mentioned to do with holidays. Juneteenth has been added to Article 11, Section 1, officially as a holiday. So that's awesome. I know that's been fun to celebrate the last couple of years, and certainly we're excited that's a federal holiday, and excited it's a federal holiday for us. And as a result of Juneteenth being added in Article 11, Section 7, there's a formula for how PTF hourly rates are calculated. So we go from now 10 to 11 holidays. The Post Service has been doing this in practice. We got them to do this before, in the middle of the last collective bargaining agreement. But this language just makes clear that, the PTFs are competent, even though they don't get paid for holidays, their hourly rate is higher as a result of the holidays. And Juneteenth is included in that calculation. Article 12, basically, we have removed a fairly significant amount of language that doesn't apply to our craft anymore. This dates back to the old joint bargaining days. I talked about the bridge memo earlier. One significant change or change that's substantive that folks should know about is in Article 12, Section 2, that talks about when someone leaves our craft for a non-bargaining job. Typically, that's going to be supervisors, and they begin a new period of seniority unless they return within 2 years. So if they leave and come back within 2 years, they lose the time they were gone, but they don't start a new period. This change is that if they do that, they do not return within 1 year, they start a new period of seniority. Okay, let me talk about a little bit of safety stuff. Article 14. We have taken an MOU that had been in our contract, a few contracts now, called District Safety Committees pilot programs. And these pilot programs have been in place where we had joint safety committees in several districts around the country. After the pandemic, I guess, and the Post Service did the restructure, a lot of people will remember, in 2021, some of them sort of fell by the wayside in the pilot test. But what we have done here is this is not a pilot. It has been moved as a new section in Article 14, a new paragraph in Article 14, Section 3, that establishes these district safety committees nationwide in every district. So it's no longer a pilot. We'll now have them in every district. I think that's a good opportunity for us to raise a lot of different issues. They have proven that they can be effective. Also related to safety is a new MOU on air-conditioned vehicles. The MOU basically says the Post Service will, do everything they can to buy vehicles with air conditioning. In reality, they don't buy vehicles anymore without air conditioning. Every vehicle they bought in, I don't know how long, has air conditioning. The next generation vehicle, which is what will replace the LOVs, and some of those are starting to roll out right now, thank goodness, they have air conditioning. The MOU also has language that in the event they plan to buy some that did not have air conditioning for whatever reason, maybe in some place where temperature didn't get over 70 degrees or something, they have to talk to us about that first. And then it's got some language, just looking really forward about kind of preventative in terms of their maintenance and inspection of the air conditioning systems. We have a few pieces of stuff related to the grievance arbitration procedure, mostly the Step B teams and that are going to be applicable more so to headquarters and the NBAs and post service areas. We have modified an MOU about the DRP testing process. This creates a task force. We've got some issues, of course, related to Step B that we need to address. We think we've got a good opportunity to do that as a result of having this task force, so to speak, in place, and along with a number of other things. That's one that we're going to get to work on ASAP, ratified or not, because it's something that we can do under the existing agreement. Then we have done something a little different. We have I guess you could call it a new MOU. It's called DRP Step B Team Procedures. And this is really taking the old DRP MOU and the DRP Task Force MOU and kind of merging them together into a new MOU. And the language, if people are familiar with those two, which are being deleted, they will recognize a lot of it. It's just there's some changes to it, but it's laid out in what I think is a much more sensible manner, and even beyond just the content in the agreement, we've laid it out with the Post Service in a way that we think will help facilitate getting to resolution on some of the issues that we have. So, and the last one I mentioned related to the grievance process in Article 15 is that we now have will have an agreement in place, should this be ratified, a task force that is going to develop and explore the use of an electronic grievance system. There's a lot of things that we could improve on with an electronic grievance system. Timeliness is one, of course. From the union side of things, you have undeniable time and date stamps and things like that. So, as most of the resources we use now, and our stewards that are out there listening, you all, the vast majority of you anyway, probably use nothing but electronic resources in terms of whether it's contract, JCAM, the grievance star, whatever it is that you use. And this would, make it so that I think we could be a little bit more efficient. And the Post Service has some interest in this, so we're going to really get to work on developing that and doing some testing. Related to Article 16, we have an agreement that would allow letter carriers that are placed in under the provisions of Article 16 and an off-duty status, which is a problem in a lot of places where the Post Service improperly applies Article 16, Section 7. But this would give those that are placed in that off-duty non-pay status under Article 16.7 the ability to use any annual leave that they wanted to offset the fact they're not getting paid during that period. Look, a natural question that comes up here is, if I use leave during that period and there's a grievance filed and, it turns out Post Service didn't have, it was improper, can I get the leave recredited? And the short answer is, we would view that no different than asking for someone to get, made whole, paid. So yes, but it just gives people the right to use some leave in order to have some income during that period. Okay, Article 17, there's a couple of things here. One is Article 17, Section 5 about labor management meetings and at the local level. And this language requires those to happen at least twice per year. I would think that places where we have productive labor management meetings happen more than twice per year. But again, that's a minimum. That's normally not a problem to get the NALC people to do that, but this will require the Postal Service at the local level. So we encourage everyone to take advantage of that. And then in Article 17, Section 7, we have made what would be, should it be ratified, a significant change to the way that we collect, or Post Service collects, and we process dues. Right now, when someone joins the union, they fill out a form. That form number is 1187. We process that form, and we have to send that form to the Human Resources Shared Service Center for the Postal Service, which is sometimes a black hole where things disappear. And as those of you in branches out there listening that have, some responsibility or involvement with membership in your branch, or the tracking or keeping up with membership or finances, oftentimes there can be a delay there. And what would happen now is we are going to take over the union, that process. So there's no more sending anything to HRSSC. We will likely modernize the way that we join in terms of turning it electronic. And what would happen is we'd be able to process that very quickly, and then just tell the Postal Service, hold X amount of money out from this employee for their dues. No different than they do now. They'll just get the information from us instead of it having to go through HRSSC. In addition, they have agreed, the Postal Service, to process allotments that the employee authorizes and that the union tells him about. So this will give us the opportunity and give our members the opportunity to say, hey, I want to, have $5, $10, $15, $20, whatever it is per pay period go to this cause. For us, that could be the Disaster Relief Foundation, that could be the Letter Care Political Fund. There's a lot of different possibilities. And the way this would happen is we just tell the Postal Service through an electronic file, you hold out X amount of money, from this employee, that'll be a combination of dues and whatever allotments our members have authorized. They would do that. The union then collects the money. We send the dues money where it's supposed to go. We send the allotment money for whatever purpose it was where it was supposed to go. So it just gives us a lot more control over the dues process and gives us a little better opportunity, I think, to make it easier on our members to participate in different things like the Letter Care Political Fund or Disaster Relief Foundation. I mean, those of you that do this know light blue, due to the kind of some of the security issues that have been out there, and the Post Service's kind of rapid effort to strengthen some of their IT security, it's become very cumbersome in a lot of cases to log into that stuff and set up allotments and that type thing. So this should make it a lot easier. All right, Eddie, I got just a couple more. Article 23 is about the union, our rights as union officials to enter postal installations. There's a new MOU that's related to Article 23. And this just makes clear that officers, representatives at whatever level will be granted that access, even if they're retired or they're in a full leave without pay status. So just really clears up that if you're retired and you've got, contractually under Article 23 business being there to do work for the union, you're going to get an ID badge. We've also got some other groups out there. We started the emergency response team where we have a group of people now. They're wonderful folks that are trained to respond and assist our members that are dealing with, when something traumatic happens, it really impacts everybody in the office, such as a loss or a serious accident, those types of things. They go in and talk to people and really give them assistance on a peer-to-peer basis. A lot of those folks are retired, so this just makes clear that they'll have be able to be issued a postal ID badge. And then the last thing I'll mention, if you read the summary, you'll see a list at the end. There's a lot more, a bunch of memorandums of understanding, MOUs, that are in our contract, in the back part of our contract, that I did not mention. And there's only a few of them that are not going to be continued. Two of them are related to FSS, flat sequencing system, which is extinct. It's gone and it's not coming back. So we don't need those anymore. So we happily delete those. And then I mentioned on the dispute resolution process, we've got a new MOU that sort of combines two previous ones. The two of those are also being deleted. But then the list you'll see at the end are MOUs that have been continued. And some of those, there's no real substantive changes to any of those, but some of them have dates and things like that we have to update in every single national agreement. Just a reminder, once again, when you get to the end of the summary, starting on the top of page 14, you'll see the pay charts. The first is just a very simple chart about wage increases and COLAs. They just list the dates, the type of the increase, and the amount, at least the ones that we know, over on the right side. And then you're going to see projected pay charts, and you have to read these things. The steps go across the top. There's one for table 1, then there's a table 1 for care technicians, and there's table 2 for care technicians. As you read across the top, you'll see the steps. As you read down the left side, you'll see the increases. You'll see COLAs, you'll see GIs, then you'll see a point where there's a new table implementation. So the stuff back a long time ago now that I talked about related to pay, when you look down at table 2, after that new table implementation, you'll see the eliminated steps. You'll see, where the increases take place. So, let me just give you an example of how to read this. Let's say you're a table 2 carrier and you're at step D. You're going to be able to look down here and say, okay, by November of 2026, that's a little over 2 years, I'm going to move up at least 2 steps, look up to F, and then you can go down, at whatever point you would reach that step, go down, look at the corresponding day to the left, and see what your salary would be. And that particular just example I just gave right now, a step D letter carrier makes $52,211 at the end of this agreement, and which would be in November if you were to move up 2 more steps, which you would, because the time frame potentially even 3. But let's just say you were going to move 2. The pay at the end of the contract would be $62,036, which just my easy quick math, that's about a 20% pay increase. So whatever your scenario is, you can see that. You can figure it out just by looking across these numbers. Last thing I will mention, Eddie, is on the CCA pay, which those projected tables are on page 15 at the very end. And as you'll see in this document, you've probably already read, there's a little short letter from me at the beginning. We really encourage you to, if you've got any questions when you read this that we haven't answered on this podcast, or feel free, please reach out to your branch officers. You can call your national business agent's office. It's really, really important that every member understands what this agreement is. That's number one, to understand the terms of the agreement, how it would impact them, what the changes would be. Then they can make an informed decision when they cast their ballot for ratification.
Okay, great. So what's next now? We have a tentative agreement. What do we do next?
Yeah, so the next thing here is we are doing a couple different things. Number one, the education piece I talked about back in the beginning of this show. We have 4 RAP sessions planned. I can quickly go through where they are. October 27th in Houston, Texas. October 29th is in San Francisco, California. October 31st, this will be a happy Halloween in Minneapolis. And then on November 2nd, we'll have one in Washington, D.C., about a block from our headquarters building. So that's cool. But these are places like 300 to 400 people in each. So, for our branches out there, the information should be up on the website. You'll see direct links to go book rooms. And I think the room rates have been reserved for example, the one in Houston is October 27th. So you could get that rate the night of the 26th and the night of the 27th if that's where you need to stay. These are going to start at 9 a.m. That my understanding is, and each of them at 8 a.m. there'll be breakfast out in the corridor lobby type area. Of course, I'll stay there and answer questions until people don't have any more questions. But I would expect that we start at 9 a.m. Most of these should be done by mid-afternoon. So, for our branches out there, our branch leaders, I would strongly encourage you, if you're able, to attend one of them. Aside from which one is geographically most convenient or fits your schedule, they will all be exactly the same. I can't guarantee I'll verbatim say exactly the same thing at each one, but the plan is for each one of them to be the same. And they are really kind of an aggressive schedule to do them in that short notice and that compressed period of time. But the idea is for us to be able to do that so our branch leaders can get all the information and get all the questions answered, and then go back for their November branch meeting and educate the members. The other thing that is happening, aside from that, of course, is the preparation of the ratification process, which is done by a mail ballot vote. We have to mail ballots and all this information to about 200,000 people. And, that's a lot for printers to take on. There also is an election here soon. So these printers are very busy with election stuff. So we anticipate that there will be very soon, I'll announce a ballot committee, which Article 16 requires me to appoint. We have the process pretty much in place. We know what we're going to do. As soon as that ballot committee is appointed, they will make a determination, and we will distribute information about the timeframes. more than likely, I think realistically speaking, these ballots, by the time they all get printed, and the ballot committee does their thing, and we get them in the mail, we're probably talking sometime in the month of November. I wouldn't think any later than mid-November. It's normally we would do somewhere in the neighborhood of a 28-day return time frame from the time all the ballots are mailed. The committee will look at that. We'll talk about that. We do have holidays, of course, Thanksgiving being there, and then December, which impacts a number of different things. So, look, at this point, there's no definitive timeline. What I will say is that when those ballots are mailed out and the information's mailed out with them to all the eligible members to vote, when you get it, if you've made your mind up whether you're going to vote, which way you're going to vote, please vote, get it back in the mail. When we do receive the ballots, the counting process is pretty it's pretty efficient. It's done by machine. So after, if the agreement is ratified, we would finish that. The committee would certify the ratification, and that would put into motion a lot of the things that we've talked about here earlier on. So for now, I would just say learn all you can. Don't hesitate in any way to reach out and ask questions. I can tell you, no matter where you are, look on the inside of your postal record, look on the website. If you don't know them already, call your national business agent's office if you've got questions, and they can answer. So just be sure you understand, talk to your brothers and sisters that you work with every day, and just be sure everybody understands what the agreement is. And the summary that we put together is comprehensive. It really covers everything, and just as I've been talking here for the last 2 hours, I guess, about everything. But it's very, very important that we understand what's in the agreement, and that our folks have the opportunity to make an informed decision.
And what's it take for a ratification? What percentage?
50%. So just a majority vote. Once we receive all the ballots, then the ballots are counted, and it's either an up or down by a simple majority.
First of all, let me be the first one to thank you for leading this, getting us to the table and getting us a contract at the table and not through an arbitrator. I appreciate that. I know you're never looking for that kind of praise, but I just want to be the first to thank you, and there'll be many more to thank you after me.
Thanks, brother.
Yep. I do, doing leadership, and we're going to go into week 2 coming up here. I feel like a little bit of a teacher, so I'm going to assign some homework for y'all. 1, make sure you're reading your summary. 2, make sure you're sharing this podcast with your brothers and sisters on the workroom floor. 3, get to a union meeting and ask all the questions you need to get asked to make an informed decision for yourself. 4, read your postal record for September and October. And if you haven't got it last week or this week coming up, then you want to go to the members only portal and make sure that we have the correct address for you so that you get your ballot. So that's the homework that I got for y'all. We want to make sure that you have an informed decision and make sure that your vote counts.
Yep.
All right. You have anything else for us, Brian?
No, all good. I promise everyone that we are back on the podcast here, and so we're going to have more episodes coming here in the near future. We just thought this topic would be this one's going to be a lot longer than most episodes that we've had or will have, but we're excited about rolling again with the podcast, and really being able to communicate, and we'll have more on the tentative agreement. I'm sure, Eddie, as we open up our mailbag, for the next episode, we'll get a number of good questions that we can answer.
Right. And the next episode will be soon, right? For all those out there in Facebook land.
Absolutely.
Yeah.
Coming soon.
That's it. Okay. So if we didn't get to your question, or you might need a clarification that you haven't got at a union meeting, or reaching out to your branch or reaching out to your business agent, you can ask it through our Ask the Mailbag segment. Submit your questions by emailing us at social@nalc.org. I want to thank you all for listening to this episode of You Are the Current Resident podcast. Please subscribe so that you don't miss an episode, and please share this podcast with our NALC brothers and sisters. You can follow the NALC on social media, on Facebook, X, and Instagram. You can find links to our accounts in the episode description, and you can follow President Renfroe on X at Brian Renfroe 19. If you have any questions to submit, again, or some feedback about the podcast for some upcoming episodes, email us at social@nalc.org. As always, may your steward be by your side, and may your union have your back. Thanks for listening.